SJC-12037, Commonwealth v. Jamal Brangan.
Good morning, Mr. Bala.
Morning, may it please the court. I'm Amal Bala, attorney for the Commonwealth. The Commonwealth is appealing from an order after a guilty verdict that declared a mistrial on the basis of certain remarks in the prosecutor's closing argument. In the time that I have, I hope to address three issues in order. First, the Commonwealth's right of appeal. Second, whether the mistrial order was an abuse of discretion. And third, whether the Commonwealth's evidence was sufficient to support the guilty verdict.
Can I just, as to the first one, ask, you would agree, would you not, that if Judge Mason had granted the mistrial immediately and not taken it under advisement, that you would not have a right of appeal?
I would agree with that, Your Honor. I think the distinguishing factor about this case is that there was a guilty verdict. Essentially, the three elements are that there was a guilty verdict, the defendant submitted a post-verdict written memorandum asking the court for relief in the form of a mistrial.
Well, the defendant really couldn't do anything else beyond what he had done, right? I mean, he'd asked for a mistrial in a timely fashion, and the judge decided to take it under advisement. I don't think the Commonwealth objected to that, by the way.
The Commonwealth didn't object to that,
And
but
so there was nothing else for the defendant to do except further protect his rights by seeking post-verdict relief, as well as awaiting the decision of the judge on this.
I would agree with that, Your Honor, but because the judge took it under advisement, it created the scenario where, in effect, the judge acted to vacate a guilty verdict. And in that scenario, I think that Rule 30 applies and the Commonwealth should have a right of appeal.
You would agree that if, let's assume the Judge Mason did exactly what he did, but the jury found Mr. Schnipper's client not guilty, you would not have any rights at that point, right?
If the defendant had moved for a mistrial before
Right?
the jury deliberated and then the jury returned a verdict of not guilty, I would agree. I would agree. And I think that that would be the standard case of a judge simply declaring a mistrial before a verdict, yes.
Well, no,
Hard
I
to
mean,
claim prejudice if someone is found not guilty.
And do you agree that if you are allowed to appeal, putting aside whether he's cross-appealed, the defendant would be able to appeal and say the evidence is insufficient for a new trial?
In these particular circumstances, I'm arguing that Rule 30 does apply and that he received relief under Rule 30. Now, aside from the fact that his notice of appeal was filed late, because I'm arguing that he received relief under Rule 30, I would agree that he has a right to.
Apart from the issue of notice, what's
Yes.
good, if you can appeal, so can a defendant.
Yes.
Let me ask you a corollary to a question that Justice Lenk asked you. I believe both of you cite the case of Commonwealth versus Murchison from 1984. And at page 275 of that opinion, I'm going to read one sentence. The following day, after a conference with the district attorney and defense counsel, the judge took the motion for mistrial under advisement, and here's the critical part, and allowed the case to proceed, preserving the right of defense counsel to renew his motion for mistrial after the jury verdict. In this case, did the defendant object to the judge's election to take the motion under advisement and not make a decision before the jury returned its verdict?
I do not believe that he did. I've reread the transcripts, and the Commonwealth didn't object, and the defendant did not object either to the trial judges taking the motion for mistrial under advisement. There was no objection to that. And I would suggest that
So which controls?
in this,
Who has to preserve the right?
well, in this appeal, the Commonwealth isn't directly challenging the judge's act of taking the motion for mistrial under advisement.
But depending on the status of this case, depending on the posture it's in, it conceivably could require a remand for consideration of
Yes.
double jeopardy issues.
Yes. But I'm sorry, Your Honor, so your question is, because there was no objection,
What's the status of this case? Is it, are we presented with a motion for mistrial that was implicitly denied, or are we confronted with a motion for a new trial that was allowed?
I am arguing that this was a motion for a new trial that was allowed. Under Murchison, the trial judge could take the motion for mistrial under advisement. Now, whether that case is slightly old, and I'm not entirely clear on how frequently that happens, but I'm arguing that because there was a guilty verdict, and because the defendant submitted a post-verdict writing, a written argument after that guilty verdict that invariably sought relief from the verdict, that when the judge granted relief, that essentially Rule 30 does apply.
The judge thought he was granting the motion for mistrial. That's what he says. He doesn't think he's granting a motion for a new trial. You
Well-
think he's granted a motion for a new trial. He thinks he's granted a motion for mistrial.
There was some indication that after the verdict, when the parties and the judge discussed this matter, that he did think that, or he indicated that defense counsel would be submitting a motion for a new trial. When discussing the matter, the judge said that a motion for a mistrial after the verdict is a new trial motion under Rule 30, and that's on March 13th on page 33.
He decided it. Didn't he say, though, that he was deciding it as a motion for mistrial? The actual decision when it came down?
But the title of his order was order granting mistrial. That's true, but
I mean, so you're basically saying that you take the judge's out loud musings beforehand as overriding what his ultimate decision actually said?
No, I'm arguing that the title of the judge's order or the title of the defendant's written argument to the court don't control the precise procedure and the appellate rights of the Commonwealth after the guilty verdict when all this occurred.
If we can turn to the left-handed.
Yes.
You agree that what the prosecutor argues in closing is not itself evidence?
Yes, Your Honor, I would agree with that.
So what is this thing of what the jury sees during the course of a trial? What is that evidence?
I do know that of course, the Mass Guide to Evidence isn't binding authority, but it does say that a defendant's appearance or demeanor in a courtroom is evidence.
Right,
That statement
I
is there
get
in the
that, but
notes.
this is more than appearance or demeanor. This is his conduct, which
It
is...
was his conduct, but under Commonwealth v. Cohen, the left-handed remark in this case wasn't erroneous because that case specifically held that when a prosecutor in closings referred to the defendant writing in the open courtroom, that it wasn't erroneous for him to suggest an inference for the jury that the shooter in that case was inferably right-handed based on the evidence, and that it was inferable that because the defendant was writing with his right hand, that they could draw that reasonable inference, that link.
I've read Cohen, but it still doesn't answer my question of what is this thing?
Well, it's not the reference to the left-handed writing.
What
it's
is
not-
when a jury observes a defendant's conduct in the courtroom, put aside his
Yes.
height, his demeanor, I know that when you have an eyewitness, so you may have a video and the jury can look at the defendant and compare it to the person on the screen. That seems inherent. And here they showed, the prosecutor sought to show the defendant to the jury, which essentially says that everybody
Yes.
seemed to agree that, and the defendant argued, well, he doesn't have the acne scars and whatever else. So everyone's sort of arguing, seems to say that his facial demeanor in the courtroom is fair game. But what is this? What is this thing with what he does in the courtroom?
If I understand your question correctly, Your Honor, I don't think that there's any precise term in the law for what's occurring here. I mean, some cases describe it as a defendant's demeanor or appearance in court. It's not evidence in the sense that it hasn't been introduced through a witness, or it's not an exhibit, obviously.
It's sort of the equivalent of the view?
It could be analogous to the view.
Chris, the interesting thing about what both the lawyers did in this case is to ask the jury to make some observations that pertain directly to the issue of identification. A view, I think, my best recollection is the judge instructs the jury that it's not evidence, but they can consider it in assisting them as an aid to understanding the evidence in the case. But here, both lawyers argued points that really went directly to the question of identification.
They did, and this was a unique case because none of the witnesses at trial, none of the eyewitnesses at trial made an in-court identification of the defendant as the bank robber. There was a police witness who ID'd him in court from the arrest. But if my memory is correct, there were pretrial motions and a motion to suppress out-of-court ID and in-court ID. There was some issue of the bank tellers who witnessed this robbery had searched for the defendant's photograph online. And so in the pretrial stage, an in-court ID was prevented. So these bank tellers who witnessed this crime they were unable to point him out in court as the robber, but they did give descriptions of their observations of his face, his nose, his height, his estimated age, whatever information they were able to give based on the fact that he was wearing a mask and sunglasses and a hooded sweatshirt and a scarf. Additionally,
So I'm sorry, but if you had defense counsel as smart as Mr. Schnipper, who says, I don't care whether you're left-handed or right-handed, when you're in that courtroom, I want you writing with your right hand. And then in closing arguments says, members of the jury, there's before you, I can demonstrate to you that my client's not guilty because in the courtroom you saw him writing with his right hand and the evidence suggested that this guy's left-handed, you must find him not guilty.
if I think I understand what you're getting at, I completely agree that the normal way of that, I would say that ordinarily in cases this should not be done. The proper way of proving whether a defendant is left-handed or right-handed is to call a witness who can testify that the defendant writes with his left or right hand. I think that everyone agrees that that is the proper way to put a fact into evidence for the jury's consideration.
You just say that the instruction that the judge gave cured it.
I would argue that the judge immediately struck the comment upon defense counsel's objection. He delivered curative instructions. They were targeted and specific. So I would argue that if this was error, I argue that it's absolutely not error under Commonwealth v. Cohen. But even if it were error, the judge struck the comment, delivered curative instructions, and the jury is presumed to follow those instructions.
But I know there's that presumption, but I mean, what if a judge who's in the middle of the trial says, you know, that's too big an elephant in the room for the jury to ignore? I don't have confidence that the jury really can adhere to that instruction. It was argued. Many of them may have seen him write with his left hand. I can't believe they can truly put it out of his mind. Does he abuse his discretion to say, I think given that this is a close case, we need a new trial?
I think that there are other factors or considerations involved, including the strength of the Commonwealth's case, and whether the inference that the attorney is asking the jury to draw goes to the heart of the case.
But
or
the judge seems to, from what he wrote, didn't seem to think it was that strong. I mean, he says there was a credible alibi witness. There was no eyewitness here. All you really had was the fingerprint on the note, which is not bad. But he said this was not an overwhelming case.
He did essentially find that, and I would respectfully disagree with that. The Commonwealth's evidence in this case was strong and sufficient. This is kind of getting into the third argument, but the testimony from the two bank tellers in this case was extensive. They gave as much or as many descriptions as they could of the bank robber. There was a surveillance video that showed the robbery. The jurors could see how the robber moved during the actual robbery. The defendant did concede that his fingerprint was on the note. Police were able to use a particular magnetic powder to lift the print off the robbery note. They used that particular method to lift prints that were left on paper more recently. And it wasn't left that recently, they have to use a different technique, a magnetic spray. The circumstances of the defendant's arrest were something for the jury to consider. The defendant, when police actually called him and asked him where he was, and he said that he was at his alibi witness's house, and police asked him to stay there, and when they arrived, he wasn't immediately there. They waited for a few minutes outside, and he came walking up the street. The jury could view him in court as well. So I would disagree with I would respectfully disagree with the judge's characterization of the Commonwealth's case as not strong.
Okay. One question that doesn't bear on the merits here. Am I correct that the police got the results of the fingerprint analysis almost instantaneously?
Within a matter of hours, yes, Your Honor.
So they basically can do that and then send it, and they were able to ascertain that's his print within hours of the crime?
Yes, Your Honor. The bank robbery occurred around 11 o'clock, and police they had his name based on the print around 3 p.m. in the afternoon, so it did happen that quickly. I will rest on my brief.
CSI in real life, right? CSI in real life, real time?
In this case, yes, Your Honor. Thank you.
Thank you. Mr. Schnipper, it's still good morning.
Pleasure to see you. May it please the court. I'm Merritt Schnipper for Jamal Brangan. Let me address the question of Cohen first. The primary difference between this case and Cohen is that in this case, the judge made a factual finding that the jury could not see the defendant where he sat writing, or at least according
Did
to
he
the
say
prosecutor.
couldn't or may have? May have
He
not.
made that finding because he said in his, that's at appendix page 9 and also page 9 of the mistrial ruling itself. And what makes that so crucial is that, we're really dealing with a case that's really at the core of of the type of findings the judge is entitled to maximum deference for. He observed the conduct of the trial itself. He was able to listen to the arguments, observe the jurors. And one thing that is so striking to me is that the prosecutor twice got up and asked the court to order the defendant to stand before the jury because she specifically represented to the court that the people in the jury box could not see the defendant because of things and people between them. So she won that motion. In other words, she convinced the court that they couldn't see him unless he stood up and stood before them to present himself to be seen, to see if he was the robber. But then when it's time to basically make this really critical argument, because there is no question that without convincing the jury that he wrote that note, that you can't convict him of this crime. So in order to make that very crucial finding, she's going to say, you sat there the entire 2 days of this trial and you watched him taking notes with his left hand. So for the Commonwealth to now say that either that's inaccurate because of Cohen or that that's somehow an abuse of discretion to make that factual finding, there has been no contention, even in the Commonwealth's brief or today from my brother, that was a clearly erroneous factual finding. And they do say that Cohen controls, but Cohen only controls in the context that in that case this court said, well, he was writing with notes with his right hand. That's not in dispute, and that sort of falls under the demeanor evidence standard.
So is the implication here that for those jurors who may not have been able to see, it was really the Commonwealth who was giving testimony as to what happened?
That's my contention, and I would note that when this court discussed the similar issue in Cohen, it specifically said the prosecutor may direct the jury to what was going on in the courtroom. What the prosecutor may not do is tell the jury his
What
or
was
her
going
own
on.
knowledge and then attribute it to them. Right, so in this case, and again, none of us were there, and we don't specifically know what the jury saw, but we know that we are required, absent a very powerful showing from the Commonwealth, to defer to what the trial judge said he saw. And the trial judge said he saw was that he specifically said, based on the layout of the courtroom, stacks of papers, and then he specifically said it's rather troubling because, the prosecutor won her argument that he had to stand before the jury because otherwise they couldn't see him and determine whether it was him. Moving very quickly to the question of whether it was a mistrial motion or a new trial motion, I would specifically say that the judge, he did not say, I'm going to deny your mistrial motion without prejudice to renewal after the verdict. What he said is, I'm going to take your motion under advisement. And then after the verdict, he said, I'm mindful of the fact that you still have a mistrial motion pending. So in his view, it was never a question that defense counsel had an obligation to re-raise the motion. And I would say that my brother's argument that by submitting, I mean, you know, when I'm in court and the judge says to me, well, if you want to submit something in writing, I take that as a, why don't you submit something in writing? So to say that, well, he kind of, he made a new motion because he filed something in writing when all he was really trying to do was write up and put some meat on the bones of a motion that was made at sidebar immediately after the offending conduct, really, I think is just reasonable attorney practice.
So you're essentially saying that, at least under Murchison, the judge preserved the defendant's right to
I think he
to continue
absolutely-
with the motion for new trial.
He absolutely did, and he said, this is my, he also said, you know, he cited Murchison in his order. He also said, this is my practice to take it under advisement.
Should we be discouraging judges from doing that?
Well, I personally don't think you should be, because I think that when you have a mistrial based on closing argument conduct, and the only thing that's left to do is instruct the jury and let them deliberate, you know, it's quite possible that the jury would have cured the prejudice or risen above the prejudice and come back with a not guilty verdict, in which case we're much better off.
But that doesn't cure it. Isn't the judge's responsibility to decide whether or not, upon the filing or upon a making of a motion for new trial, isn't a judge's responsibility to determine first whether a curative instruction will suffice, and then if the judge is satisfied that it won't, then to move for a mistrial,
I think that,
or
let's put
allow
it
the
this
motion for
way.
mistrial.
If this court comes down with a rule that says you need to rule on mistrial motions immediately, it will obviously prevent a situation like this from ever happening again.
Because you have, I mean, you do have the right to, and he could have just granted a new trial right there.
He absolutely could have, in which case, obviously, we wouldn't, I mean, I would still frankly be arguing for a sufficiency
You are,
analysis.
yeah,
But,
sure.
you know,
Sure you would.
the Commonwealth would certainly not be appealing, and we probably would have already retried this case, and it would have happened the way it would have happened.
Except that upon the retrial, there would have been an issue of double jeopardy
There still would have been
in
the
what
right
the
to
what
make
the
a motion to
prosecutor's
dismiss,
conduct
211-3,
was.
absolutely. That still would be in play, as with the Berry issue itself, whether the Berry rule extends to a mistrial granted in this circumstance, which I certainly think there's no real reason that it shouldn't. I mean, either way, that rule is predicated on the idea that once the Commonwealth has a full opportunity to make its case and fails to do so, you know, the rights protected by double jeopardy prohibition kick in, and the Commonwealth is not subjected to any sort of deprivation of its rights because it's had the one full opportunity, which really differentiates it from a, you know, a goading mistrial issue mid-trial. Because here we're saying, you know, all right, you had your entire, like, in other words, legally there was only one outcome of this trial that could have happened, a not guilty. The fact that the jury perhaps was won over by this improper argument, or perhaps was swayed by the fact it doesn't want to see any more bank robberies to convict, does not necessarily mean that we have to uphold that or allow a second trial when legally the required outcome of the trial was a not guilty verdict. Now, with regard to the sufficiency of the Commonwealth's case itself, and specifically the question of, you know, really this case hinged, I mean, it really hinged on this fingerprint evidence. And obviously, there was a motion to suppress. Well, that evidence has been suppressed and is not before this court, neither is the motion to suppress itself. But the Commonwealth simply failed, given the importance and really just dispositive nature of the fingerprint evidence and scientific evidence that devolved from it in this case, the Commonwealth simply failed to make its case. I mean, the expert was only able to say, we produced this fingerprint on this note through a method that is used to find things that have been touched recently. No, there was a voir dire about whether he could give any further evidence in terms of the timing of the print, and the judge found that he could not. There was no separate scientific evidence to talk about the half-life of fingerprints or the impact of different compositions of papers. There was no evidence about whether the ink with which the note was written went on before or after the fingerprint. So there was none of that. And I think, you know, it's really, we're not doing anything harsh when we say to the Commonwealth, you know, if you're going to make your case, you need to make your case. And at this point, you're not going to be able to go back and backfill. And I would specifically say with regard to any other evidence, you know, the descriptions of the robber were between 5'5" and 5'7". It was confirmed by a police officer witness that the defendant is 5'10". That's a significant difference. There were no descriptions of weight or build from anybody. The only apparent piece of the bank robber that was visible was the man's nose. He was described as being African-American, but with a wide variety of descriptions of skin tones. You simply can't say, I mean, which one was right and which one was wrong. There's 4 different descriptions from 2 different tellers. So, I mean, there's clearly no sort of physical identification evidence. And I would really say, I rarely say this type of thing, but this court's decision in Morris is completely controlling here. When you have a thing brought to the scene of a crime with a fingerprint on it, Again, in Morris, expert evidence that says, well, this is a fragile surface to hold the fingerprint. It's not going to hold it particularly long. And I would say in Morris, there was eyewitness testimony that the person who was wearing that mask, quote, resembled the defendant, Defendant Morris. I mean, here there's no question of a resemblance. I mean, you know, racial congruity is not enough for resemblance, so we're just basically at a stage where we have a fingerprint on a note, no exclusion of the reasonable hypothesis that it could have been placed somewhere else. The bank robber is on videos wearing gloves, described as wearing gloves, so it's really beyond question that he didn't impress a print on the paper at the time of the robbery itself. And I would say when you have a case like Morris, or like this case, or like the appeals court's decision in Renaud, where you've got a chattel at the scene of the crime, the fingerprint evidence is even weaker, just at a common sense level, because if you have a fingerprint on the door of a bank, on a surface of the bank, then you know that the person who left that print has been at the bank at some point. And then the question becomes, well, you know, did he have an account there? Is there any other surveillance video showing him come in another time? Things that are potentially susceptible to proof. Here what we have is a piece of paper. We have no idea of its provenance. Again, we're talking about the Commonwealth's burden and did it carry it? We have no idea of the provenance of that paper. We have no idea of the timing other than you said, well, we know that this magnetic spray would not have brought forward a print that was made days or weeks ago. So days or weeks gives us, as I said, you know, charitably to the Commonwealth in my brief, at the very least, you're talking about a window of a few hours based taking the Commonwealth's evidence at its strongest. And that still does not exclude the hypothesis it was made at some other time. And given the gloves, frankly, I feel like that's more than a hypothesis. It's conclusive that that print went on at some other time than during the robbery.
And was the print over the writing or in a spot other than the writing?
Unfortunately, the government's evidence, and there was no evidence about that, and the government did not carry its burden of proof. The defendant didn't produce any separate fingerprinting evidence.
Can I go back to something? I'm not totally clear of this mistrial, new trial. Are you saying if we were to say discourage judges from reserving the right to rule on it after the verdict and say you really shouldn't do that, then what gets lost there is, right, that from a defense point of view is to be able to argue that because if the mistrial were granted, you would say, quite apart from the sufficiency, I think you would say, right, it's the Commonwealth's fault.
We would still have the goading argument as well. You mean the sort of the no retrial because of misconduct
That's
separate
right.
from sufficiency?
That's right.
Sure.
I mean, you lose that, right, if you do it, if you.
You mean if we allow it to go over or if we require an immediate ruling?
No, if you allow it to go over, do you lose that?
I don't think you, because you, first of all, I mean, you don't necessarily lose the right to argue goading, but you specifically, you know, you don't, I mean, I think you probably do need to put it on the record at the time of your oral motion. I think she goaded me into moving for this mistrial.
So then if it's at the new trial, if you say we're in the new trial, then you sort of have you have potentially two arguments. You've got sufficiency, I mean, depending on the facts.
Sure.
And you have the goading.
Right, and so I do think, I mean, where I think that there's an interesting play here is if the defendant wants to move, just to assume this exact scenario, after closing argument before jury deliberations, I want to move for a mistrial based on bad closing argument by the Commonwealth. And the judge says, I'm going to take it under advisement, you know, and then I think the defendant probably should be required to say, I need you to consider the goading issue as well. I mean, I don't think, because a mistrial is one thing. You're saying, the well has been poisoned, my client can't get a fair trial. I think you don't need to really say anything more than that. It does make sense to submit a written memorandum after, or at least have a longer argument. The goading question is really separate, right? And it's really, you know, I think so. In that sense, I think the defendant should preserve the goading issue here. I mean, here, the judge found no goading, and we aren't arguing goading.
Okay.
But the question about the sufficiency or the adequacy of a curative instruction, shouldn't that be aired fully at the time that the judge makes a curative instruction? The defendant could then say, Judge, this isn't good enough. You know, something happened here that is far more serious than you were able to undo with your curative instruction.
I acknowledge your argument, but I would respectfully suggest that when you say, I want a mistrial, you're not saying, she argued facts not in evidence, and I would like you to direct the jury to not regard that because it was facts not in evidence. I mean, that's a separate objection that people make during closing argument. But here what we're saying is you have so distorted the trial. I mean, implicit in saying a mistrial needs to be granted is saying the 3 check marks that this court identified in Thomas about what a judge determines in the discretion of whether or not to grant a mistrial, the third of which is whether a curative instruction will be enough to cure the prejudice.
But that
You're
can be
implicitly
aired.
saying that's not enough.
That can be aired at the time the judge instructs the jury.
You're right. So in other words, you could, what I don't think we want to encourage is judges making off-the-cuff mistrial rulings. So I think it would be certainly possible for the judge to say to the jury, we're going to take a brief recess, we're going to come back and instruct you, and then have a closed hearing just between the parties about the mistrial and go into it more fully.
But don't we also want judges to decide whether or not the curative instructions they gave were adequate and whether they could give perhaps a more forceful curative instruction
think we
that
want
would
them to
avoid
decide that.
the necessity for a mistrial?
I think we want them to decide that. I think in this particular case, in his written statement, he basically said, I gave the curative instruction, but I don't think it was enough. I don't think this was such a central, because, there's a lot of different things that would provoke a motion for a mistrial. This is really the very central dispositive fact of the entire case that's argued based on facts, not on evidence. So I think it's a very particular scenario, but I also think that reading into the judge's behavior and his written memorandum, it's pretty clear that he thought that the mistrial needed to be allowed pre-verdict. But he said, well, let me see what happens, because maybe we'll get a not guilty and I won't have to deal with it, because I don't think any judge wants to grant a mistrial if they can allow a jury to resolve the issue fairly.
But isn't this, it's a tough issue as to what this handwriting is. I'm not sure if I know yet what we call this thing, and
I think as a general
and the
matter,
Cohen
it's tough.
case, is he supposed to know that the Cohen case,
Well, he
to
looked at
ask
Cohen,
a
obviously.
judge to basically, you're sitting in closing argument, this thing comes out of the blue, and you're asking a judge to say, you need to
It's
decide
evidence,
this
it's
while
not
the
evidence.
jury is about, ready to you're about to go into final instructions and jury instructions, and say that it's not appropriate for a judge to take some time and think about this and do some legal research?
I do think it's appropriate to allow them to, and I don't personally have a problem with the procedure the judge followed here. I have a problem with the Commonwealth's appeal, and all the time it's chewed up. But just in closing, I know my time is up, but with regard to what this thing is as a more general issue, I think you're right on the money that it's a bepuddling issue. But in this particular case, the judge specifically said this is not evidence because the jury couldn't see it based on my own observations and the prosecutor's representation. So I think in this case, that challenging issue really isn't need to be resolved by the court.
Thank you.
Thanks so much.